Hi, I'm James, a real estate agent in Oakland County, Michigan. I actually don't just only work Oakland County, but right now, for the purposes of this video, it doesn't really matter. The purpose of this video is to go over the exclusive buyer agency contract with you. There's a lot of speculation around these contracts and a lot of skepticism. People don't want to sign. However, if you're a buyer and you're looking to sign as of August 17th, 2024, you are required to sign a contract if you would like an agent to assist you with purchasing a property. We are not allowed to show a property without having this exclusive buyer agency contract signed. So, let's get to it. First of all, you're contracting out an agent to be your buyer's agent, your buyer's representative. So before I get to the contract, I'm going to read a clause out of the disclosure regarding real estate agency relationships that specifically applies to a buyer's agent. So I will read it. It reads as follows. Buyer's agent. A buyer's agent under a buyer's agency contract agreement with the buyer acts solely on behalf of the buyer. A subagent of the buyer is one who has signed to work with the buyer's agent and who, like the buyer's agent, acts solely on behalf of the buyer. Buyer's agents and their subagents will disclose to the buyer known information about the seller, which may be used to the benefit of the buyer. So, what we have here is an agency relationship being formed. And until the contract is signed, you do not have a buyer's agency relationship with any realtor or real estate agent. So the purpose of the contract is because once you sign with an agent, you're going to see a house. Obviously, you must be in the market to buy. That is actually costly for the agent. Sometimes the agent might charge, sometimes they may not. Typically, you get more experienced agents who will. Less experienced agents, they're pretty much trying to get the business and they don't want to run off the client. So, regardless, you have to have this signed. And typically, the sellers are the ones that pay the commission through the seller's agent, the listing agent, as it's referred to in the disclosure. But I will start on the contract, and I'm not going to touch on every single clause. I will mention every clause, but the ones that are significant to you that you probably care more about are the ones that I'm going to address today. So the contract, this here is a typical GMAR contract. It's nothing fancy. It's not specific to any particular brokerage because different brokerages do have their own version of this and they have it for a reason. But this right here pretty much covers everything that needs to be covered. And if you don't want to go along with the contract that the specific brokerage uses, you can ask for one that's more basic. But it starts off with the broker, the designated agent, or maybe it's a traditional agency, but I typically do. I'm a designated agent. When you work with me, you work with me. You're not working with anybody else pretty much but me, and my broker would be considered a supervisory agent. He's not going to be involved in the transaction much at all, if at all. I will, just like your designated agent would be as well, if you choose somebody else. But it's not about me contracting out with you right now. I just want to just share some information so you have a better understanding of the contract. So we'll start at clause number 1. Number 1, purpose. Broker designated agent, and supervisory agent shall be the only parties with an agency relationship with client. Client hereby appoints designated agent as client's exclusive agent to assist client to locate, negotiate, and secure property as described in paragraph 3. Designated agent accepts the appointment, and designated agent services shall be limited to consulting with client regarding the desirability, particular properties, the availability of financing, formulating acquisition strategies, negotiating buy and sell agreements, leases, options, exchanges, and facilitating the detail of the transaction. Now, I'm going to skip down here to number 3 because number 1 specifically referred to number 3. Number 3, property. Client desires to purchase, lease, option, exchange, or otherwise acquire real property, which may include items of personal property, meeting the following general criteria. Now, this is the section where it gives you the description of what it is that the agent is assisting you with, whether it be residential income, commercial, farmland, industrial, vacant land, or other. We specify that because you may be working with a different agent for some other reason, but in this particular circumstance, you're only working with one agent who is going to be your designated agent for the purpose of finding the property that's listed on here. Now, the reason why this is really important is because an agent starts off assisting the client. And that's why it shouldn't be such a big deal for the client, because what you're getting is the agent's experience and knowledge. You can definitely benefit from the agent's experience and knowledge when you're navigating the transaction, trying to find a property. You're trying to go see the properties. Once you find one, you're going to want to submit offers. If you submit an offer, you want the offer to be intelligent. You hope to have it accepted, actually. So it's more to it than just filling out the paperwork. It's more to it than just throwing out a number. You have to check the market. You want to check the comps. You want to see if the other property already has offers on it. If so, how much you're going to need to offer in order to secure that property. An agent's experience and knowledge is imperative if you want to be successful in your endeavor. So that's the reason why you need an agent. But at the same time, you can't just expect an agent to start investing in you, which that's what you are as a client. You're an investment to the agent. Even if the agent requires a deposit, you are an investment. And like any investment, you put a little something into it and you hope for a return on your investment. And sometimes that's not the case. Just like any other investment, you can lose, as is the case many times. As with an agent working with the client, if the client never buys anything and no payout, then the agent is left holding the bag with the bills. So, which brings me to clause 18. I want to go in sequence, but these are pretty significant clauses. And since I'm on the subjects, I might as well go right to it. Clause 18, client responsibility. The duties of the broker parties contained herein do not relieve client from the responsibility to protect the client's own interests. Client should read carefully all agreements to ensure that they adequately express the client's understanding of the transaction. Client has been advised to seek legal, tax, and other professional assistance relating to any proposed transaction. Client further acknowledges that the broker has informed the client that the title to the property could be subject to restrictions, easements, liens, and other encumbrances, and that the services of an attorney are necessary in order to evaluate their effect on the title. Now, that brings me to clause 15. Indemnification of broker. Client agrees to indemnify broker parties and to hold harmless on account of any and all costs or damage arising out of this contract, provided broker parties are not at fault, including but not limited to attorney's fees reasonably incurred by broker parties. Now, as a sales agent, we are not contractors. We are not inspectors. We are salespeople. We're not even loan officers. People like to confuse the two, but a loan officer or a mortgage broker is different from a real estate sales broker or a real estate agent or realtor. We help you to find and secure properties.